Hey there, everyone. Welcome back to the Better SMB podcast. Hey, this episode is going to be an immediate classic. We have interviewed Ben Kane from James and Wells Intellectual Property Lawyers. Now, on their website, they call themselves Excellence in IP, and my gosh, he has delivered on that. Ben has been able to take all of this complexity around IP law and what it means for SMEs and break it down into some really knowledgeable chunks so you as a business owner, leader, manager can really just increase your awareness and risk around IP and what you can do about it to protect your business. We love this episode. We continued the conversation a lot longer than what we thought, but the time will go quickly. I am sure you're going to listen and pick up an amazing amount of information that you can take back to your business so it can become just that much better. Anyway, that's enough for me. On with the podcast.
Welcome back to the Better SMB. I'm David Alterner.
And I'm Rob Bull.
Today we've got a guest, and our guest brings a combination of real-world commercial expertise and deep legal expertise to the world of intellectual property. Interestingly, he didn't start his career in law, and in fact, at 21 he told his father he'd never be a lawyer. But that was before he discovered the world of intellectual property and how critical it is to building and protecting successful businesses. Starting out in the UK in the early 90s, selling label and tag printing solutions in the south of England, it was there he learned firsthand about innovation, customer relationships, and what makes a business thrive, even one that seems as niche as a label printer. He then moved into brand and product marketing, holding senior roles at companies like Sellotape UK, Boots Healthcare, and later working with some of New Zealand's top design agencies, including DNA Design. After moving to New Zealand, he made a bold pivot, retraining as a lawyer, bringing over a decade of commercial and branding expertise with him into the legal world, with a clear focus on intellectual property. Today, he's a partner at James and Wells, or Jaws, as it is sometimes referred to. He's a regular contributor to the Bay of Plenty Business News and a frequent speaker at events across the country, most recently Tauranga's Daybreak Festival of Innovation, run by Priority One. Welcome to the Better SMB, Ben Kane.
Thank you very much indeed, David and Rob. Nice to be here. Very much nice to be here. It's an honour.
That was probably one of our longest intros because Ben has done an insane amount of things. So well done, Ben. You've got, the biggest CV, the most illustrious CV of all the guests we've ever had. And we've had some pretty cool guests.
You have. No, thank you very much. It's not the usual career path, that's for sure. I think most IP lawyers I've ever come across have basically been lawyers ever since they came out of university and got into law and then carried on. I know a lot of lawyers who graduated too and then got out actually of law and went into commerce. And in that respect, law is a really good foundation. But for me, it was it was actually a chance meeting. I wasn't thinking about the law. I was working for DNA Design at the time back in 2006, and I met a trademark attorney who, funny enough, lives in Tauranga as well, and met her, and we started talking brand and trademarks, and I don't know, something just sparked in my mind, and I thought, actually, maybe that's what I'd quite like to do. And so I went away and I read some books, and I thought I'll give this a crack, and so I went to law school, went to Te Parenga, went to the University of Waikato, and I said to myself, if I'm any good at this and I enjoy it, then I'll stick at it, because I was 38 at the time, so it was pretty risky. And I thought, but also if I'm not any good at it or I hate it, then I'll give it up and I'll go and work in a garden centre or something like that. Fortunately, I was quite good at it and I really enjoyed it, so I stuck at it. But it was always with doing, as David said in the intro, it was always with a view to doing intellectual property, because having had that marketing background and then having had design agency experience, it made perfect sense to do IP law, to be able to take all of that experience and bring it to bear for the client's benefit.
One of the things I really enjoyed about engaging with you, Ben, is that you're just not a typical lawyer at all.
No.
And you're able to communicate these things that can be really, really complex in straightforward terms that, well, I understand for a start, but then most business owners can understand. When we think about intellectual property, what are some of the examples of that a typical small business may not even realize that they've got?
Yeah, no, thank you. Good question. So most business owners, small, medium, or large, they know what a trademark is, typically speaking, or by which they will associate a name or a logo. And those are pretty fundamental to any business. What they might not realize that they've got are, and it depends on what business they're in, but they might not realize, for example, that if they are in FMCG or any kind of physical product, they might not realize that they are potentially able to register what we call a 3D trademark, for example. So that protects the shape of something. It can protect the packaging. It can protect the look of something. If they're in a retail space, they might not realize that they can also protect a particular layout, either as a trademark, a retail layout, either as a trademark or registered as a design. If you're in the computer space, you can now register graphic user interfaces as designs. So there are all heaps of different types of intellectual property assets out there that unless you investigate or unless you ask, you don't necessarily realize that you might actually have. You might even have invented something and that is potentially patentable. Unless you have the knowledge, unless you ask the right people, talk to the right people, it might be an opportunity that just passes you by.
You've talked about a few things there, like trademarks and designs. Can you just dive into those a little bit to expand on what that means?
Yeah, for sure. So trademarks, when we talk trademarks, we typically talk, as I say, names and logos. But in a very technical sense, a trademark is basically any sign that is capable of being represented graphically. So that's really important. So you've got to be able to see it. And it must be able to distinguish the goods or services from one trader to another. It has to be the way by which you stand out. And unless it performs that function of distinguishing your products or services from somebody else's, then it's not really functioning as a badge of origin. And that's essentially what a trademark is. It's a badge of origin. But because it's basically fundamentally a sign, it can be anything. You're kind of only really limited as to your imagination as to what it can be. So if you can make a brand or a color or a device, a label, a name, it can be a smell, it can be a sound, it can be a taste, any combination of those things. All of those things can function as a trademark. So if you're the owner of a food business, for example, and you've got a particularly flavorsome food and nobody else has got a flavor profile quite like yours, or you might be a wine brand, a startup wine brand, or even an energy drink or any kind of beverage for that matter, if there's a particular taste or flavor profile, then you might be able to register that as a trademark, because if consumers come to associate that particular attribute with your brand, then you can potentially register it. It's really important too that with a trademark, it has to have what we call a distinctive character, and that's kind of like the same message as a distinguishing something. So if it can separate you from the crowd, then it can perform that function of distinguishing and perform that functioning of distinctiveness. Easy examples are Apple for computers. So an apple, is a fruit, obviously, but it doesn't describe computers. And it's a really good example of a trademark that is distinctive and distinguishes the products and services of what used to be, when it started, a computer company from everybody else. Google is another great one because it's an invented name. But any trademark that performs those functions, it will distinguish your goods and services from somebody else. Yeah.
So, Ben, just as a quick thing, as a consultant, we've met each other a lot of times, and we probably did meet at a networking function. So I rock in with jeans and always with a orange pair of shoes or a colourful pair of shoes.
Yeah.
Is that and people go, oh, that's Rob, because that's his kind of the way he presents himself. I've dropped the duck t-shirt. I know that's quite distinguishable. The way I present myself, so the guy with the colourful chucks, is that good enough?
Yes, in a brand sense, it is. If people come to associate a particular look and feel, for example, or a particular name or logo or color, if they come to associate that with your business, with you, as it were, then that's performing a trademark function. That's performing as a badge of origin. So if it's you, Rob, and you come in and you've got the same orange sneakers each time, and the same perhaps color shirt, you come in and it's like, oh yeah, it's Rob. I recognize that it's Rob. And that's what consumers do every day. When they go, down a supermarket aisle, for example, you will recognize colors. In particular, you will recognize colors before you can see words. And you will know instantly what brand that is by denoting the color before you see the word. So Whittaker's, you can't see, for example, the word on the packaging, but you can see that it's gold. So you know that that's Whittaker's chocolate. When you see purple, you know it's Cadbury's. And you're doing that because the messages that those trademarks, those what we call get-up or brand appearance, you have become to associate those colors and the appearance of that packaging in your mind as a consumer. And in that sense, then, the brands themselves have done their job. They are acting as key indicators. They're acting as badges of origin for their companies. So when you're a small business, when you're a medium-sized business, it's really important that you focus on that, especially when you start off. But if you get the opportunity to rebrand, or you have to rebrand, then it's really important that you focus on creating these indicia that consumers will instantly recognize as being from you.
And then you've also touched on registering designs.
Yeah.
So how are those different to trademarks?
The designs are a really underutilized resource in New Zealand. They protect the shape and configuration of a manufactured article. It can be anything, from a forklift design to a battery design to a glass design to a bottle design. I mean, the mind boggles as to the possibilities, really. But it protects the shape and configuration, and it also protects the pattern or ornamentation on something. So take, for example, a cutlery set, and obviously knife, fork, spoon, and they each have a particular pattern that goes around the handle. So you can protect that pattern on the handle across that range. It might be a piece of packaging, so you can protect the pattern or ornamentation that's on a piece of packaging. Again, it might be a computer screen, so graphic user interface, you can protect that. So again, as long as the design, the visible design, falls within shape or configuration, or falls within pattern or ornamentation, then you can protect that. It's a really underutilized registered right here, because we have what we call industrial copyright protection. That protects drawings, for example, for a product for a period of 16 years as soon as you make the 51st item from that drawing. You plug in your CAD drawing into your machine, it pumps out the 51st, whatever it is, and then immediately your period of copyright protection drops down from 50 years beyond the death of the author down to 16 years. And a lot of businesses, small to medium businesses in New Zealand, they're aware of this right and they heavily rely on it. The trouble is that right is not available overseas in any of our major trading partners. It's not available in Australia, UK, Singapore, US. They don't have that right at all. What they have is the registered design system. So if you're in a space where you could potentially register a design, you should absolutely be looking to do that. And you need to do it as well before you make it public. So let's say, for example, you are a new brand of coffee liqueur and you've got this really cool bottle shape and you're itching to tell all your mates about it and put it up on social media. That would be the worst thing you can possibly do until you've applied to register that design with the Intellectual Property Office. Because as soon as you publicise it, you void any application you make. So it has to be, at the time you file the application with IPONS, it has to be hush-hush. But if you apply to register it with IPONS, then potentially you can springboard off that application and register your design in Australia and the UK and everywhere else. I've heard stories of businesses, they come up with this fantastic design, they focus on New Zealand as their marketplace, and then lo and behold, somebody across the ditch nicks the design and runs with it. And they come to us and they go, oh, what can I do? And you have to say nothing at all, I'm afraid. If you had registered the design, you would have been able to stop them. But because you didn't register the design, you can't. And it's a really unknown right. I mean, for myself, for my part, I try and talk about it as much as I possibly can because we have such an immature designs register and it's such an underutilized right. But it's such a powerful right, though, as well. So for any design-led business, whether it's physical product or graphic user interface, whatever, you really, really, really need to be looking at what your design registration possibilities are.
Wow, quite a bit in that to think about. If we look at why that's important, so if we'll pick on Rob. Rob's not getting any younger. At some point, Rob might look at selling his business and deciding he's going to go live somewhere warmer, which helps out his arthritis. So if Rob's looking to sell his business and he's got no trademarks and no registered designs and nothing like this, or he does have those, that to me seems like quite a big benefit or value add for someone who's looking to buy Rob's business and support him in his retirement.
Yeah, absolutely. They're really important. I do a lot of work with startups. I attend the ADI clinic that's run by Enterprise Angels in Tauranga. And one of the things I know investors, for example, or people looking to acquire businesses always look for are IP rights, evidence of IP rights. And the reason that that's important, especially for small and medium-sized businesses who are perhaps looking to scale up and looking for investment, or whose owners are looking, one day to basically sell and go and put their feet up, is because there are barriers to competition nicking your ideas, basically nicking your intellectual property assets. And if your IP assets are, as they are in many cases, the foundation of your business, if you delay thinking about IP protection, if you delay securing IP protection, then somebody who's going to be a potential shareholder takes a look and goes, no, I'm sorry, it's too easy for somebody to copy you. If you're looking to sell your business and they come along and they go, I see you've got an excellent business. Okay, so what trademarks you got registered? None. Okay, well then what design protection have you got for this particular, bottle or widget or whatever? None at all. Okay, so what then is to stop somebody from copying you? Oh, I've got copyright protection. Well, actually, no, you don't. Not outside New Zealand anyway. And this particular product, let's say, is more than 16 years old, so then you don't have any protection at all. Oh, okay. Well, thank you very much for your time. I'm not interested in buying your business. So registration is really, really important if you can get it. You've got to think long term. This is the thing. A lot of small to medium-sized businesses who have not introduced themselves or who haven't had the benefit of some good advice early on, they come to the IP table either too late or so far down the track that they're then trying to scrabble and go, okay, well, what can we do now? And potentially significant opportunities are lost if they don't do it. And by significant opportunities, you can translate that into dollars, when it comes to sell. Yeah.
So talking about dollars, we'll use that as a segue because in the back of my mind, I've got a few things, might get some free advice or might cost me another bottle of red wine, but startups, small businesses, cash flow's king, we're busy doing the work, all of that kind of stuff. So what's how much is this going to cost? What's a ballpark? I mean, it might be a piece of string. And how hard is it to actually just secure that? Because, I'm sitting here going, oh, is this like going to the dentist and I have to get a second mortgage, or is it $250 and at least the dot has started to be dotted?
Yeah, yeah. So it is a bit like a piece of string because there are a lot of factors in there that can affect cost. So if you're a small business just starting out, for example, then the first thing you could look to do is register your trademark. Okay, you want to register your name, and don't just look at New Zealand. If you've got global aspirations, 5 years, 10 years, but let's keep it 5 years, because 5 years is a really important time horizon, or 3 years especially is a really important time horizon in IP rights sense. If you're sitting there going, okay, well, I'm here now, cast your mind forward. Let's say, where do I want to be in 3 years' time, ideally, and then bring yourself back and go, right, so I might just be starting as this humble business in Tauranga or Hamilton or wherever, but where do I want to be in 3 years' time? So bring it back. You can do it yourself for next to nothing, really, literally the official filing fee, if you are confident enough to have a look at the trademarks register and figure out what we call a specification of goods or services might want to be. I've done it myself, so both before and after being a lawyer. Because there's no copyright and specifications, what I mean by specifications is the list of goods or services that you apply to protect your trademark against. So let's say you are in business consulting. So think of another consultant, all right? Think of another consultant, plug their name into the trademark register and see what they've got their trademark registered for. You can go, okay, well, that looks pretty much like what I do, copy and paste, because there's no copyright in it, so you're not committing anything illegal by doing that. So if you're confident enough to be able to do that yourself, then you can do that yourself, at least starting in New Zealand, and potentially in Australia and potentially the UK as well. The more complicated your business is, though, and the more jurisdictions overseas you're looking at, and the more what we call classes of goods and services, then it starts getting complicated. And then I would absolutely recommend you talk to an attorney, talk to an experienced trademark attorney in terms of securing IP protection, trademark protection. In terms of budget, I would say it's like with any business, plan it out. What are my costs going to be? How am I going to pay for this? So if I've got, let's say I want to register a trademark in 4 different countries, and I know the bill's going to be about $4,000, something like that, then I go, okay, well, can I spread this payment? So if you need to work with an external lawyer, be upfront about it and go, hey, look, I'm a startup or I'm a medium-sized business, but I'd really like to pay this off over 2 or 3 months. Is that okay? Most IP lawyers will go, that's absolutely fine. They'd rather be paid than not be paid. And so that's fine. I mean, I know at James & Wells, we're very open to having payment plans for clients. So we'd rather help a client get their rights and secure their rights and be on a payment plan than the client not get their protection at all. It's exactly the same with patents or designs or plant variety rights. There are varying levels of costs, but work it out. I think the biggest mistake that businesses make is prioritizing money on stock and on marketing material and pushing aside IP rights.
So anything between a couple $100 to $4,000 or $5,000.
And the rest, depending on
real complex stuff. Yeah, absolutely.
Yeah, real complex stuff.
As a ballpark, we're getting started. I'm just trying. I'm trying to drag a real number out of a lawyer, which is really hard, I know. But, but yeah, if I'm putting aside in my budget, right, I can get through some of the basic trademark stuff. Yeah, I can do that. That's going to be a couple $100 as a self application.
Yeah.
And when it gets a little bit complicated, I'm going to put aside in the next 6 months $4,000 to $5,000.
Yeah, put aside $3,000 to $5,000 and see where you go.
Excellent.
One of the things you do need to do, though, and this is where a lot of small to medium-sized businesses make mistakes, is not doing clearance searches. What I mean by that is in the patent space, you have a thing called a freedom to operate search, which is basically, if I've got this invention, does it infringe on anybody else's patent? It's a similar thing in the design space and the trademark space. We just call them clearance searches. Do a search. I want to go, let's say I'm advising Rob. Rob wants to take his business to Australia, the UK, and the US. I know this because Rob has said to me, this is my plan. So we go, okay, well, we should do clearance searches then in Australia, the UK, and the US. Now, those can cost, if you're doing what we call an exact or similar search, they can be about $500 per country. Or if you're doing a much more in-depth search, then that might be anywhere between $1,500 and $3,000, depending on how complicated it is and how many countries you're going into. A lot of businesses look at that clearance search and they go, I can't afford to do that. Well, let me ask these businesses this question then. What will it cost you to defend a trademark infringement proceeding if you launch your brand in an overseas country and you haven't bothered to check whether anybody else is using or registering the trademark that you want to use? How much will it cost you to rebrand and lose all the goodwill that you have acquired in that brand over the last however many years? I have clients all the time. I've got a few of my books at the moment. Great Kiwi businesses, great Kiwi success stories, SMBs. Sole focus has been New Zealand, now looking to go overseas, and they can't use their trademark overseas because somebody else has got an identical or similar mark. So they are now faced with restarting, rebranding, and all the goodwill that they've got, that they've built up in that brand, all that sweat equity, right out the window, gone.
I guess a great example of that comes to mind would be Hungry Jack's over in Australia.
Yeah. Yeah, absolutely. That's why it's called Hungry Jack's and not Burger King.
Yeah.
You know.
So we've talked about the cost. We've talked about the risks of getting it wrong. On the other side, the value add side, when these organizations are selling their businesses and they've got these trademarks and registered designs and so forth, what sort of difference are you seeing in multiples for, the profit to price paid multiple that a business is receiving as a result of doing things well?
Gosh, I can't actually answer that question. It's really anecdotal. The evidence that we have is anecdotal to some degree because of looking at clients who have come to us saying, we want to sell our business. We're looking at selling our business. Can you do an IP audit? And we go, okay, well, let's have a look. What have you got? What have you not got? Or it's going through a forum like Enterprise Angels, and you're seeing it firsthand there where businesses are pitching to a room full of investors and they're going, we've got our IP locked up. I remember actually there's one specific example. It was not that long ago. I won't say which one it was because they'll probably be able to identify it, but it was one not that long ago. And it was a software app, and the person was standing up in front of the room full of 60-odd plus investors, and the person said, our IP is locked up, and we're looking for $250,000, whatever it was, for 10% stake or whatever it was. And I sat there and I thought to myself, well, what IP have you got? Because you've got a trademark registered, but you're a software app. And the only IP that's recognizable within a software app is copyright in the code, because copyright subsists in software code. And then I said, so I actually asked the question. I said, do you use a third-party app developer, or do you have an in-house developer? Oh, we have third-party app developers. Oh, okay. And what does your software agreement with them say? Does it say you have a perpetual license to use the code that they write, or do you actually own the code? And this person said, oh, no, they own the code. We have a perpetual license. So I said, so in that case, actually, you don't own your IP, do you? You've got a trademark, and you've got the goodwill in the trademark, but you've got nothing else. And the kind of room went a bit hush-hush. And I felt a bit mean, actually. But then this was a classic case of a small business owner not knowing what IP actually that they had and unintentionally misleading investors to say, oh, no, the IP's all locked up. No, it's not. So it's really, it comes back to an education thing, I think, that it's incumbent upon business owners of any size to learn about IP when they are the foundation stones for any business. It's really incumbent on business owners to learn about IP, how they can plan for it, how they can use it, how they can increase the value of their business. So we know it increases. I can't name a multiple. I genuinely can't. But we know it increases their value because investors come along and they ask, what have you got that's protected?
So I guess it could mean the difference between a typical small business is selling with a 3 to 5x multiple. It might mean you get 4 to 6.
Yeah.
because you've got your IP locked up, right? So
Yeah.
it definitely is worth your while
Yeah.
to
And it
get.
might mean you're in a competitive environment too, that you've got more than one person who's pitching for you. They go, oh, this great. These people, they've got their IP locked up. They've got their registrations in these countries, etc. They've got this sorted and so on and so forth. Yeah.
So confidentially or anonymously, are there stories you can share about people who have got it wrong? Like you've touched on some organizations that have had to rebrand given different markets they're looking to go into and that sort of thing. But is there a horror story that kind of stands out for you? And then on the inverse, what about the crowd that got it right? And
Well, on the wrong side, there's a couple of classic tales here. The first one is a business that never became a business. Sounds a bit cryptic, but what I mean by that is the person who had a fantastic idea for a product, designed the product, got prototypes made, and then went out to the market to try and attract investment, but without having put in place any confidentiality agreements, without applying to register the product for its design, without having applied for any patent protection. And because it's been put up on social media, somebody overseas has gone and looked at that and gone, I like that. I'll have that. Thanks very much. And next minute, you see it on Alibaba. And I know stories like that. And, that person who thought that their retirement was coming true is no longer the case. So that's where somebody's got kind of carried away, but without looking at the start and going, right, how can we lock this up? And the second part of business is that, as I talked about first, they've started local but didn't plan for global. And they are too many in my book. The one that Rob and I, as I say, mentioned before, that's a classic, but they're not alone by any stretch of the imagination. I know one a few years ago, successful business in New Zealand, looking to go to Australia, exactly the same thing. Somebody else in Australia had their registered trademark. The biggest horror story I actually have is from pre my days of when I was a lawyer. And it occurred when I was at a design agency back in the late, when would this be? 2006, something like that. Back in those days, if you were applying to register trademarks in a number of different countries, you had to file an individual application in each individual country. Now we have this wonderful thing called the Madrid Protocol, where basically you can file one application through the World Intellectual Property Office in Switzerland, and then it, like spider legs, it will drop all the applications into each of the regional offices. But it's one application, one set of fees, and then it all drops down. Back in those days, though, you didn't have that. And the agency had a client, very successful client, and they had applied to register a trademark in 16 different countries. That's a lot of countries, but this was a big brand. And in 15 of the countries, they got the trademark accepted. In the 16th country, they had a problem. Now, this 16th country happened to be the second biggest market for this client, and they hadn't done any searching. They hadn't done any of this clearance searching. They just filed all their applications. God knows how much it cost them. It must have cost them a fortune. And in the end, they had to abandon all of the applications in all 16 countries because they couldn't get that one over the line in that 16th country. If they had done searching, and it's the same, it was the same then and it's the same now. If they had done searching, they would have realized that, they would have known that, and they wouldn't have gone ahead and chosen that particular brand. That's probably the worst example in terms of scale of lost monies. But all the time I see frequently businesses who could have registered designs, for example, but didn't know about the right and therefore didn't secure the right, and then now they've lost the opportunity to do it because it's out in the public domain. Converse, ones that have got it right, again, there are lots of those. And a business that gets it right is a business that includes IP in its planning process from the start. It doesn't treat IP as an afterthought. So if you take, for example, if you're an SMB and you go, right, we want to launch this new product or we want to launch this new service, the typical thinking is that you don't think about IP at that stage. You think, okay, what's this product? What's it going to be? What's it going to be called potentially? Who do we use for as a design? When are we going to buy stock? And you put your business plan around it, and you put your marketing plan around it. I know of no examples, I have to confess, and I'm happy to be corrected by listeners. I would love to be inundated and told I'm wrong, but I know very few businesses which, as part of that business planning and marketing planning process, go, right, what IP rights do we want to secure in this process? And so the businesses that do it right are the ones that include it in that process from the start. There's one business here, actually, an outdoor company, an outdoor clothing company. They used a local Tauranga Bay of Plenty design agency to design a clothing pattern for them. And design agency's credit, actually, they said to the client, they said, hey, you should protect this. And so before the product was even launched, the client applied to protect the pattern for the clothing, as well as the trademark at the time. And here we are. I think it's nearly 10 years later. The design is still there and the trademark is still there. So there's an example of a business. Perhaps they didn't, think of it themselves, but their design agency helped them with the process, or helped them say, hey, you should protect this. But that's a business that gets it right. There are lots of multinationals, of course, who get it right. One of our biggest clients here is a manufacturer of respiratory masks. And of course, as you would expect, with an international company like that, they have a very solid IP program and a very solid IP process. But not many SMBs do that. But the more that they can adopt that big company thinking into their businesses, then I think the better off they'll be.
What I'm hearing is it could be a 6, 7, maybe even 8-figure mistake if you get this wrong and can't even take your product to market, as your example of the business that never was, versus the value in getting it right. Again, that could potentially be enormous as well. So investing a few $1,000s to get the right advice, as a bit of a sidebar and kind of off some of the questions we prepped you on. What are you seeing with clients coming to you now going, I just use ChatGPT for that? Or Gemini?
Yeah, or Copilot. What we're seeing is the use of literary AI, if you will, with clients for cease and desist, that is, or letters of demand. So that ChatGPT is, to the best of my knowledge, and Copilot, for example, I'm not very good at trademark specifications, at that really kind of nitty-gritty thing. And you don't need to use them either. You just go along, as I said before to Rob, you just go along to the register and see what a competitor's doing and go, oh, yeah, that looks good and I'll have that. Thanks very much. So ChatGPT is, I think, being used for those introductory letters of enforcement, cease and desists. We'll give it a go. We'll save ourselves $1,000, $1,200. And if it doesn't work, then we'll go and talk to the lawyer. We see AI being used a lot in the contract space. So there's some very good AI apps out there in the contract space. IP is a funny one, though, because AI is not, ChatGPT, Copilot, etc., has not yet made a proper incursion, if you will, into our space. And it's because it's so technical. We have colleagues who are constantly looking, for example, at AI drafting a patent specification. Yeah, it's okay, but with a patent specification, it's so technical. If you get it wrong, you really get it wrong, and you only have one kind of shot at it. So it comes with a degree of risk. So we're not seeing it being used for patent specifications. We're not seeing it being used for trademark specifications or design registration application. Yeah, it's really in that legal correspondence, I think, where we are perhaps feeling the biggest impact of it. Now, of course, in the AI space with generative AI, one of the big conversations going on at the moment is in terms of images and the use of Midjourney and OpenAI and Adobe Firefly and so on and so forth, the use of those generative AI platforms by creatives, by marketers, and by design agencies. Bearing in mind, I think at my last count, there were 16 cases of infringement going on in the US where IP rights holders were suing AI companies. None in New Zealand at the moment that I'm aware of, but I would anticipate that most, if not all, of those US cases, they will succeed. The IP rights owners will succeed. So that's the biggest kind of debate where we are being asked questions, or I'm being asked questions a lot at the moment, is, okay, well, there's no copyright in AI images. No, not necessarily. If you put some instructions into Adobe Firefly and it produces an image, you could potentially be infringing copyright, depending on what the text prompts were that you input. Chances of somebody coming after you are probably pretty slim. But on the downside, if you're a brand owner, you've got no ownership of the image, your competitor could use exactly the same image and you've got no rights to fend them off. There is a thing called transformative copyright rights, which is what I think Steve Ballantyne and Brand AI in Auckland, Brand IQ rather in Auckland, they are an amazing agency when it comes to AI and AI generated imagery. A lot of what they're doing could be classed as what we call transformative copyright, which is where you basically have a starting point and then you transform that current work into a new work. It's all pretty murky. Yeah.
Brilliant. Which comes back to the how long is the piece of string, right? When you're pricing Rob for his IP and trademarking and registered designs and so forth that he's going to potentially need.
Yeah. Well, on that price,
I just pay by a bottle of wine, by bottles of wine. I'll put an S on it, multiples.
Well, I think that's the other interesting thing, though, in terms of AI, actually, is in searching. Sorry, I didn't mention that one is in searching, is that there are some really cool AI platforms for searching, and they're not cheap because obviously the amount of money that's been invested in these platforms is considerable. And we at James & Wells, we have access to one of those platforms, but we pay a considerable amount of money to subscribe to it. But there's no doubt that I think there's downward pressure on pricing, especially in the trademark space. You know, it's seen as a commodity, and so it's become a real challenge, I think, for IP firms to figure out where the new territory lies. How do we shape our services going forward?
Probably quite a good segue into this question. With your background in branding, how do you see IP intersecting with building a strong, recognizable brand for businesses to be able to really differentiate themselves?
It's fundamental. When I think back to my time as a marketer, I was involved very heavily in developing or literally designing new brands, coming up with the names, working with a designer on the logos. I worked very heavily in product design, physical product design, in packaging design, web design, brochures. It's fundamental. And I think gone are the days where you can operate as a marketer or as a designer in branding and not think about IP, not think about what assets you are creating and that you want to protect from the outset. Over the last year or so, I've been having some fantastic conversations with design agencies, for example, about IP assets and trying to enhance their knowledge of what assets are available and shaping their design to shape their design thinking so that they're not just designing fantastic outcomes for their clients, which they do, but thinking about IP from the outset. So if they are given, for example, a new brief to develop, to reinvigorate a piece of packaging, then their brief is directed as much by the IP asset they're trying to create as much as it is on the design aspects of it. So, you know, what are their competitors? What are the competitors doing? What colors are they using? And so on and so forth. So if they approach it from a point of view of, right, we want to get a registered trademark for this, or we want to register a design for this, how does that then influence the design pathway? And at the moment, there are not many agencies, I don't think, who are thinking in that way. They're thinking in a traditional sense, which is great. They're producing great designs. But what might the path have taken if they had thought with the end goal being an IP asset in mind? So I've always talked about three sides of a same triangle. You've got clients, let's say at the top, marketers at the top, let's say, agencies down one side, and then IP firms down the other side. And design agencies and IP firms are great at talking to clients, but we're really hopeless at talking to each other. And so the more that design agencies can talk to lawyers, lawyers can talk to design agencies, the more then the design agencies can talk to their clients in IP context, then we turn that triangle then into a circle and into a wheel that keeps moving and going round and round and round, and the whole IP cycle just moves far more efficiently. And so I think it's absolutely fundamental. IP is absolutely fundamental in building that strong, recognizable brand.
Well, SMB owner who's listening to this and has pretty much gone, holy shit, and they've gone white and they've realized they've got nothing in place, what should they be doing after listening to this episode?
First thing I would do if I were them was do an IP audit. Sounds a sort of fancy term for basically just sitting down and going, okay, well, what have we got? We've got our name. Yes, we've got our logo. What else have we got? And if they're unsure about what it is that they've got, then pick up the phone to me. If they have another IP lawyer, pick up the phone to them. I'd rather pick up the phone to me, of course, but we'll pick up the phone to James and Wells and say, I'm a small to medium-sized business. I've got a name, I've got a logo, but I don't know what else I've got. Then let's have that conversation, do an audit. And at the same time, stage one is the audit, and then stage two is to talk about where are you going? What's your plan for the future? In that, then they can go, okay, well, then let's approach this next stage, this next phase of our growth, this next phase of our development with the correct approach to our IP assets. I did a workshop. I was very lucky to have done a workshop for the Rise Food and Beverage Accelerator in early March. And subsequent to that, had a number of conversations with about half a dozen SMB food companies. And all of them were pretty much in that space. Some had registered trademarks, others didn't. One is a very new drinks business, just really starting on its journey. It's got a heavy focus at the moment on manufacturing. And we're kind of going, hold your horses, guys. You've got great ambitions, but let's just wheel it back here. Let's do an audit of where you are. Where do you want to go? And then let's put these steps in place so that you can achieve everything you want to achieve for your brand and your business without having taken any missteps along the way, at least as far as your IP is concerned.
Is there a recent example of an organization being able to enforce their IP rights you can provide us with?
Yeah, there was one. I don't know if you guys, I don't know if this is going to be in it, but there was an article in the Herald on Friday about a designer called Sarah Lilly, I think it is, and she spotted her designs on Shein. Is it Shein? I always thought it was Shine, but Shein. Yep. Yeah. Journalist Tim Rose reported basically saying that the Intellectual Property Office in New Zealand IP is domestically protected by IPONs, which is not true. But also he said that legal action can be expensive and time consuming. And my only sort of comment on that, and I don't know if it's sort of right in here, was, yeah, it can be difficult for small businesses to enforce their rights. Yes, absolutely it can, because it can be expensive. But if there's one other bit of information that I would add, it's that very, very few businesses that I'm aware of provision for enforcement of their IP rights. They don't you can't take out IP insurance. You used to be able to. You can't anymore. So a good business like Rocket Apples, I can say this because it's in the public domain, Rocket Apples puts a proportion of its revenue aside each year, or it did the last time I heard, towards enforcing its IP rights. It's its own insurance policy. A lot of businesses, the vast majority that I'm aware of, do not do that. And so when it comes to something like this particular event, the business has got no money to spend on a cease and desist letter or to take any legal action at all. But to me, I don't see the logic in that. I genuinely don't see the reasoning in that. You take out house insurance, you take out car insurance, you take out business insurance. Why wouldn't you take out insurance if you're a business which is IP heavy, which is IP led? Why would you leave it all to chance so that if that day comes when you have to enforce your IP rights, your war chest is empty? It makes no sense to me at all.
Just a last quick question, really. I get it around, you said that sort of that IP heavy businesses. Like, I can get it where manufacturing, you're making a widget or something like that, food and beverages and all that. Which sectors, give just 2 or 3 sectors that are the worst in sort of getting their heads around that they actually have assets that are worthwhile calling you up for?
Yeah, FMCG. And I don't know if that's because products products may have a short life cycle. So it's either because they're seasonal. I can get it if they're seasonal, but let's say, you've got marketing managers coming in and changing the packaging every 2 or 3 years. But why should that preclude you from registering a right if you can, if it acts as a defensive mechanism to keep your competition away? So FMCG is not necessarily the best. By extension, food and beverage are not great. I think they definitely could be better. And I'm working very closely with the New Zealand Beverage Council at the moment to try and improve that IP knowledge, that IP protection. What would be another one?
Because I'm curious about professional services. That's David's in that space. I'm certainly in that space. And even on this conversation, I'm going, I'm going to have a chat once I get back home. And there's a whole lot of things that we're putting together now that might be worthwhile just having a bit of an email over your way afterwards.
Yeah, professional services can be. I know of some professional services companies, they don't bother registering their name or their logo as trademarks, even if you can't register the service itself. It's not, there's a lot more registrable rights available for physical products. Even in software, if you're in professional services, then the question is, how would you lock it all up? Well, confidentiality agreements be one, copyright potentially, which is not a registered right, but if you know who wrote what, when and how and so on. Is there any design registration? If you're investing, for example, in a consumer facing website, we now know that graphic user interfaces can be protected, both actually as trademarks and designs. So is there something that you can register there? We have clients in the honey industry, and it's terrible. The honey industry is terrible for people copying each other and trying to sell very close to the wind. And it's not much easier to enforce a right if you've managed to be able to get it registered. Again, it comes back to when you're designing something new. So if you're about to relaunch your website, for example, then are you designing it with an IP asset in mind, or are you designing it with just the design in mind? Because if you're designing it with trying to secure a registrable IP asset in mind, that is inevitably going to change the path of how you design and what you design.
Well, give me some jobs to do tomorrow. Brilliant.
Recently as well, maybe a month ago, there was an Australian company called Dream Farm Pty, and they had designed a juicing device, which they called a flusser. And you basically chop your lemon in half, you pop it into this, looks like a garlic crusher, but on the side instead of like that, and pull it together, and you squeeze the juice together. You bring the two arms together and you squeeze the juice. And they had applied for patent protection in the USA and in Europe, but they had not applied for any protection, patent or design in Australia, their home country. I don't know why. It's an interesting decision, because Kmart came along, did an audit and went, oh, they don't have any registered design protection. They don't have any patent protection. We like that design. We will copy it. And they did. And so they went to China and they got a copy made, 95% copy made, and selling it in Australia at Kmart, and selling it in New Zealand as well, for that matter, for the princely sum of $5 Australian or $7 New Zealand. Now in Australia, the flusser costs $20. And that is a classic example of the consequence of not even getting the most basic design protection in place. Now, if that was in New Zealand, they could have, and actually, in fact, Dream Farm Pty still could sue Kmart for copyright infringement, because they've got that industrial copyright protection. Pyrrhic victory, really, if they did it, because they're not going to stop Kmart in Australia. And so, so that one's, there's an example where register protection was available and they just did not take it. I don't understand that.
That one's got to hurt. We'll wrap it up there. Thanks for your time, Ben. I've certainly been scribbling notes while we've been recording this episode, and I can see Rob has been too. You've given us a great starting point for business owners and leaders to think about how they can incorporate trademarks, registered designs, and other IP considerations. A key takeaway for me also has been it's never too late to move away from what you're currently doing, especially if there's something you're more passionate about and can build a career or business around. Your success really does speak to this. Today's episode builds on the themes from other episodes that we've had, such as episode 3 with Simon Walker, business value and being exit ready, episode 4 on my productivity research, actionable steps to build a high-performing and valuable business, episode 7 with Grant Johnson, bootstrapping and brand evolution, episode 10 on innovation, turning ideas into assets, making innovation count by protecting it. For those of you out there looking to understand more about what you may be able to protect in your business, please reach out to Ben. We'll have his LinkedIn details in the show notes. Thanks for listening and being part of the community we're building with the Better SMB.